Hi, welcome to Governance Bites. I'm Mark Banicevich, and today it's my honour actually to spend some time with Lloyd Kavanagh. Thank you very much for your time, Lloyd.
A pleasure.
Lloyd is a senior partner at MinterEllisonRuddWatts. Actually started his career at RuddWatts and Stone as it was at the time, and then spent about a decade working in companies like Fonterra, and has then returned to law. Has over 25 years experience in governance. He's currently on the board of the National Provident Fund, but he's also done not-for-profit boards as well as for-profit boards. He's done boards in New Zealand and overseas, including things like Lawyers for Climate Action New Zealand, AMP Services New Zealand, Soprole, is it?
Yes, Soprole, largest dairy company in Chile.
In Chile.
On the board of that for 4 years.
While you were there at Fonterra?
Yes.
Right, absolutely. And then time in the Securities Commission, which of course was superseded by the Financial Markets Authority, and has also been on the board of MinterEllisonRuddWatts. So thank you very much for your time and your expertise today, Lloyd. I really appreciate it.
Delighted.
Today we want to talk about the challenges for directors of subsidiaries. So it's quite common, of course, to have a company structure where you have a parent company with a number of subsidiaries. Those subsidiaries may have different boards from the parent company, and it can be quite enticing at times for the directors of the subsidiary to act in the best interest of the parent, which may not be possible or in the best interest of the directors given their liabilities. So what unique challenges does this kind of relationship bring, Lloyd?
I think it's a great question that you're raising, and given the proportion of New Zealand business which is owned from overseas, particularly in financial services, but also domestic business, I think it's a key issue. The starting point is to remember that in our culture and legal regime, the responsibility for governing an organisation sits with its board of directors.
Yes.
Not with its shareholders or owners. Now, they have three primary duties: to act in the best interests of the entity that they're on the board of, and we can come back to that a little later, not to trade recklessly, which again is a whole issue on which there's been some recent case law, and to make sure that when their entity incurs obligations, they have reasonable grounds for believing they'll be discharged. And so each of those obligations need to be thought about as a starting point in terms of the company whose board you sit on.
Mm-hmm.
The challenge, of course, when you are on the board of a subsidiary is you probably also work for the parent company, or at least the parent company owns the entity that you work on. So you have a whole bunch of incentives to make sure you're thinking about the shareholders' interests, which, when we talk about the best interests of the company, that's usually assumed to be the best interests of the shareholders collectively. But it also takes into account other stakeholders, particularly creditors. And when we talk a little more about financial services, it can be customers as well.
Right. So, I mean, ultimately, a company is a legal person, and as you say, if you're on a director of a company, your obligation is to act in the best interests of that company, regardless of who the owners are and what the owners' interests are. So by default, you've got to act in the best interests of the subsidiary if you're on the subsidiary's board. So are there any circumstances when you can actually act in the best interests of the parent, even if it's not in the best interests of the subsidiary?
Well, the New Zealand Companies Act has specific provisions that say if the constitution of either a wholly owned subsidiary or a majority-owned subsidiary or a joint venture say that the best interests of the parent can be taken into account, you can act in that interest even if it's not certain that it's in the interests of the subsidiary. But having said all of that, that doesn't override those other two duties I talked about, right? Which is what's called reckless trading, which is essentially not to undertake risks which involve a serious risk of substantial loss to the creditors of the company.
Yes.
And that is not overridden by the right to act in the best interests of the parent. And then also that when you're incurring new obligations to customers or suppliers that you believe on reasonable grounds that your entity is going to be able to deliver on those obligations when they need to be performed.
Okay, so in summary, if you're on a director of a subsidiary, if the Constitution allows it, then you may be able to act in the best interest of the parent, so long as you're not breaching
those other two
major duties.
You know, and we had a really good example that was in the news media recently of a case called Mainzeal, which went all the way to the Supreme Court. And what happened in Mainzeal is basically you had a major construction company which had in the distant past been listed on the NZX but had been taken over by Regina Pacific and was a wholly owned subsidiary. And they had a board some of whom were representatives of Regina Pacific and some of whom were appointed as independent directors. Basically, ultimately, what the Supreme Court found is those individual directors were personally liable because they had run the company or allowed the company to be run in a way which breached those other two duties that I've referred to. And essentially what they were doing, construction's inherently quite a difficult business, they were relying on soft assurances from the parent that if they ran out of capital, don't worry, we'll see you right. And of course, when things got really tough around the time of the GFC, that additional capital wasn't available. And so it was those directors who were then personally held accountable in different proportionalities, given their involvement, for not having had adequate regard to the external stakeholders, the non-shareholder stakeholders, which were particularly creditors and those customers for whom they were undertaking work.
And they were quite significant fines too, weren't they?
Well, it was more than fines. It was in the order of damages claims.
Right, yes.
And those were, I think, around 38 million in total, apportioned across the directors.
3 directors?
Yeah. In the end, some resigned. And I think the key thing was, which is the challenge for everyone who sits on a subsidiary board, is to make sure that you are thinking about your own creditors, and that if you are relying on parent assurance that it's legally enforceable and you know that the parent will be able to deliver, because I understand one of the issues in that case was money would have to come out of China. China, of course, has foreign exchange controls, and getting a government agency to pour more funds, to approve exiting funds from China to put into a company which is struggling in New Zealand might or might not come about.
So having a binding legal agreement is one part of it, but doing your due diligence to ensure that there are resources and capability to deliver on that agreement.
You have to have really clear grounds for believing that every time you enter into a new commitment that you'll have the resources to deliver on it when you're called on. And another thing in that case, which was particularly instructive, is you've got to balance sometimes the interests of existing creditors with future creditors. And if you're taking on new business, essentially to enable you to address the existing liabilities to existing creditors, that can get you into trouble as well.
At which point are you trading insolvent?
Yeah,
right, okay.
And the financial services sector, there's probably a couple of additional glosses. Often in financial services, people have a license. So registered banks really are sort of licensed deposit takers, licensed insurers, fund managers, derivatives issuers. They all have requirements that don't allow them to defer to the interests of the parent. It kind of reinforces that you can't have that provision in your constitution, but that provision in your constitution doesn't get you out of the woods anyway if you are in a position where there's a substantial risk of serious loss to creditors.
Right. So in summary then, generally, if you are on the board of a subsidiary company, you may be able to have a provision in the constitution that allows you to act in the best interests of the parent, unless which doesn't allow you to contract out of trading recklessly or acting or
taking on new obligations
that
if you don't think you're going to have the means to discharge them.
And then even then, there are some industries where you are not able to do it at all because of other
where
regulations.
You've got additional regulations, but all those regulations are mostly doing is focusing your interests on the fact that you've got relevant external stakeholders whose interests need to be in your mind as well.
Right. Now, is the New Zealand approach quite unique, or are there similarities overseas? How does it differ in different jurisdictions?
In broad terms, the regimes are similar across at least the, I guess you'd call them the Anglo jurisdictions, so New Zealand, Australia,
Canada,
UK. Yeah. I think one thing that Mainzeal case highlighted is New Zealand has put in its Companies Act a stronger emphasis on the position of creditors.
Yes.
So there are either different interpretations or greater safe harbours unless you are clearly in an insolvent position for companies incorporated in those other jurisdictions.
Right, because if you're talking about a cross-jurisdictional relationship where you've got a foreign parent and a New Zealand subsidiary, the officers of the parent may have quite different assumptions about what the subsidiary is permitted to do than what we're able to do based on New Zealand laws. So the New Zealand director really has to get their head around what our own obligations are and push back on foreign parents if necessary.
And that can be quite challenging. I personally had to be very clear about that when I was on subsidiary or investment boards on behalf of Fonterra, to be very clear with the people who are setting my KPIs that's absolutely, we have objectives to deliver on, but I'm going to have a personal responsibility. For example, in Chile, where Soprole was at the time only a 51% shareholding by Fonterra, and you had minority shareholders who were very keenly making sure we were always acting in the best interests of that company. For example, if we decided to build a milk powder processing plant in the south of Chile, that we were doing that in that company's best interests.
Yes.
And I guess being a lawyer by training, even though my role wasn't legal, you can imagine I was quite focused on doing that, doing that properly.
When there are minority shareholders, it's probably a little bit easier to keep in mind that you can't act in the best interest of one party because you've got other parties that are involved here as well. When you're a wholly owned subsidiary, it's probably a little bit more easier to fall into the trap of saying, you own us, so we'll do it for you anyway, and you still can't.
And likewise, when you asked about licensed financial service providers, it's kind of a little bit easier because you've usually got pretty clear statements from either the Reserve Bank or the FMA that make clear what their expectations are.
Yes.
That you can specifically point to. It's important to remember that those expectations apply to all the directors, not just those who are designated as independent.
Yes.
But it can lead to some interesting dialogue. But when you haven't got that to point to, it can be quite challenging when you've had a shareholder appoint you to a role to say, thank you very much. Yes, of course we're focused on the business performing, but we've also got to weigh these other things. A classic example is when there's a dividend that the parent wants to be paid, and you're going to have to weigh up paying that dividend versus making sure you've got adequate capital for the running.
And probably a very common example.
It could well be.
Okay. Thank you very much, Lloyd. I've got one final question for you. In your 25 plus years in governance, both advising company boards and being on them, what's the best advice you've received?
Wow, that's a great question, which could be a whole podcast in itself, I think. I'm going to call out two things. The the first is being really clear that you know who your various stakeholders are, not just whoever has appointed you, but how all of that maps out. But then the other thing, which I think is applicable to boards where you're in non-executive director roles, is you should spend 90% of your time asking questions. So remembering, of course, you know, you're as part of the governance of the organisation, it's powerful and well-focused questions that actually help make sure management is doing the right things rather than telling people what to do. Right.
Well, that's been great, Lloyd. Thank you very much for your time. I really appreciate it.
Delighted.
I'll look forward to catching up again soon.
Okay.
And
cheers.
See you next episode. If you've got any ideas for topics, please pop them in comments because it'll be great to keep this series going. So have a great day. Thank you very much for joining me.